Welcome back. You're watching NewsX. I am Meenakshi. Upreti. The top focus of the bulletin remains the Gyanvapi verdict. A Varanasi district court today rejected the plea of the Anjuman Intizamiya Masjid committee challenging the maintainability of the suit filed by 5 Hindu plaintiffs in the Shringar Gauri Gyanvapi case, ruling that the plea seeking permission for the worship of Ma Shringar Gauri, that is inside the Gyanvapi mosque, was maintainable in the court of law. Their petition will be heard now on the 22nd of September. Meanwhile, the Anjuman Intizamiya committee that represents the Muslim side is set to move the High Court. As per reports, there are reports coming in that the Hindu side may seek now a court-mandated survey inside the disputed premises and demand an investigation into the shivling which was found in the Wuzu Khana area of the Gyanvapi mosque. What does this verdict mean? Why it is being called as a watershed or a historic verdict? Can it have any ramification or fallout on similar controversial or contentious cases? Let's open it up for discussion. Advocate Khushbu Jain, senior lawyer with us, Sumit Peer, political commentator with us, Major Mohammad Ali Shah, representing the Impar panel with us, KV Dhananjay, advocate of the Supreme Court, also with us. I'm going to start first of all with you, KV Dhananjay. What do you make of this verdict by the Varanasi court today? The Hindu side, of course, is seeing it as a big win. They say that now they are going to approach the courts, perhaps ask for a carbon dating of the shivling and even an entire survey of the complex to be conducted by the ASI.
Well, I think some celebration is in order, but I don't think too much celebration is warranted just as that, because the Places of Worship Special Provisions Act of 1991 actually comes in the way of the Hindu petitioners obtaining the relief that they have actually primarily sought from the civil court. The relief that they have in fact sought is that they should be permitted to pray on a number of days in a week and so on and so forth. That prayer is expressly barred under the Places of Worship Special Provisions Act if we take the factual position to be that the place is currently a mosque. And that if on 15th of August 1947, if it would be possible for the court to ascertain what in fact was the use to which this particular building was put to on 15th of August 1947, and if the court could say that it was principally a mosque, but there used to be a puja on the outer wall of the mosque at 1 or 2 times a year, and that practice continued unabated, then in that event, the most that the Hindu petitioners would be able to get is the declaration or the permission to similarly continue that practice, because apparently that practice was stopped at the height of the Ram Janmabhoomi demolition dispute. So not yet, because the Places of Worship Act of 1991 it continues to be the same that it was when it was passed in 1991. And if these, there were similar attempts by other petitioners. They have not been able to make any progress so far. So it's quite unlikely that these petitioners too would be able to achieve something that the previous petitioners have not been able to. Now, notwithstanding the discovery of the shivling. Now, what happens if only the court could possibly say that, well, this is a shivling and that it is being used in the mosque for a different purpose, then the court would have sufficient power to direct removal of the shivling and then to be transferred to a different place. But shivling, that kind of power is always available to the court, and the Places of Worship Act does not bar the court from removing an object which in fact is not part of the worship in a mosque, because shivling has nothing to do with the mosque. So if shivling is there and shivling is not being used for the purpose of worship by Muslim the groups, then I think the court certainly would have the authority and the power to direct removal of it. I think, yes.
Yeah, but again, sir, as far as the 1991 Act is concerned, yes, in this case it wasn't applicable because this petition was limited to the right to prayers. But similar petitions are pending in various other courts as well. When we are not talking about, of course, changing the basic structure or tenant of, a religious or a contentious religious building, but when it comes to right to offer prayers, do you not think, Advocate Khushbu Jain, if you could come in here, that this case can have a larger ramification on other cases as well? For example, the Krishna Janmabhoomi case.
No, absolutely. See, what you started is what to understand that today's order or what this petition that in question that we're talking about was restricted to applicability, or was restricted to the to the application filed under Order 7 Rule 11 of CPC, where it just which specifically talks about that you cannot get into the merits or demerits of the matter, but you have to look into whether at this stage parties can go ahead and file any claim or not, whether they are barred by any limitation. So restricting that to barring of the limitation. Now, when I specifically talk about what they're claiming in this petition is that this suit practically cannot be entertained because limitation comes in play, and limitations, the challenge under limitation is that Section 4 of the Places of Worship, that is Special Provision Act of 1991, specifically provides for a bar. So that was in question. And if I may just put in what exactly Section 4 of Places of Worship of Special Provision Act of 1991 states, it says that the religious character of worship existing on 15th day of August 1947 shall continue to be the same as it exists on that day. Therefore, the party which, the current suit which you are talking about, the parties to the suit were required to prove in the court regarding the religious character of the property in question, whether it was prevalent on 15th August of 1947 or not. And I think looking at the facts, there is no contention about existence of deity in that premises. Yeah. Existence of the temple and prayers being going on, and the restriction which I think Sir was also talking about came after the Varanasi incident, that after the incident that happened, that it restricted to prayer one day in a year instead of every day the prayers used to go on. Now, looking at the facts also, I think there are things which are available. Also, Hindu law, if I may just quote, specifically talks about the property which is once vested in the deities shall continue to be the deities' property.
Yeah.
And even after the destruction, or even after the destruction of that property or a deity, it cannot change the nature of the property per se. So I think that's also another aspect one has to look into. And I mean, I'm not specifically getting into the merits and demerits of the matter, but I'm restricting myself that when it comes to limitation, I think that part is very clear, and it will pave way to a lot of other matters which are pending across India.
Exactly. And Sumant Peer, Hindus say that they've been denied their basic right, their right to pray for years altogether, and that's why many are today interpreting it as a historic verdict, right? As of now, that right has not been granted, but at least a hearing is going to be conducted, because the Muslim side was hell-bent on trying to prove that there is no hearing that can take place, because they claim that the structure was protected under the 1991 Act. At least that part has been clarified by the court, and perhaps that's why it is such a significant judgment, isn't it?
Meenakshi, it's a significant judgment in more than one ways, because if you look at the Act when it was brought in, it was looking at the current, where there was a turmoil in the country, the Act was brought in. The Act, if you look at it, it's a one-sided Act, because the Act goes against the principle of natural justice. Because as in natural justice, what our constitution is based on, what our legal system is based on, and as per this Act, you're not even supposed to go to a court, you cannot even appeal, and you cannot even submit your case in a court. So nobody is claiming that this is a mandir or a masjid, it's a different issue. But even after this Act, after 1994, people were already worshipping there. So even by this Act, which came into existence in 1991, the puja was happening till 1994. Now, by this Act, it has paved a way for a lot of things, and it has, paved the way for natural justice to prevail in the country. Now, not as a Hindu, as an Indian, as a justice system, it's good for all, because you cannot have a one act bought by one government which can just take away my fundamental rights, because the fundamental rights as a Hindu are guaranteed by the constitution. How can you bring in an act which can, take away my fundamental rights from me? It is for the court of the law to decide what it is or what it is not. But when there is historical evidence there, when there is this Aurangzeb, this Halafnama, whatever other orders are there, when you can see the visible signs of a Hindu deities on there, now you discovered the Shivalinga there, now radio carpet dating and all things are natural. Now, how does a dispute settle? Where does it put as a different matter altogether? But the good thing is that with this precedence coming in place, that blanket no, what was the Muslim side trying to do? Why did they go to the Supreme Court? They wanted Honorable Supreme Court to shut down this case at the first hearing. By 1991 Act, no questions asked. It's like a situation, no appeal, no vakil, no dalil, I won the case without fighting it. Well, that is not what the constitution guarantees me. If I'm a Hindu, I have a right given by my constitution. How can one government of Congress bring an act and debar 1.5 billion Hindus living across the world from their basic rights? This is what has been nullified today. So if the case has merits, it has to be listened. The court of law will hear it out and then will decide on the merit.
And Major Mohammed Shah, end of the day, of course, when it comes to the 1991 Act also, it's under the purview of the Apex Court. They are looking, of course, at various sides. Many petitions have been filed against it as well. But talking really about the verdict of the day, there's a lot of fear-mongering also which is taking place. Many reactions have come in which say that this verdict could destabilize the country. What would you say today? End of the day, what is really needed is to find a middle path as well. Peace and prosperity paramount, but at the same time, what's wrong in trying to look at what the history says and, as I said earlier, rectifying historic wrongs?
Meenakshi, I truly appreciate the fact that you are conducting this debate in a very, very fine, mature, level-headed manner, and you spoke about the middle path, which is very, very important in today's world, especially to exist today. Now, you know, the Places of Worship Act of 1991, which says that whatever was the status quo of the place of worship on 15th August 1947 should be maintained. So initially when this news broke out and when there was this major debate happening, I, for example, thought, where's the debate? Where's the matter? Why is the court even hearing it? It's all very, very clear. It's clear. Where's the ambiguity here? But slowly and gradually, as I studied further and observed the case further, I got to know that the ambiguity is that people are contesting that the whole thing was a temple apparently before 15th August, or well, if that was the case, then I'm very curious. Like Smriti just said that, you know, until 1993, if I'm not mistaken, Smriti said something like that. I see it's very easy to sit on a TV panel and talk. A Hindu can say it was a temple, a Muslim can say it was a mosque, and both can argue and both can debate. But ultimately, the matter is sub judice in the court, and it should not be looked upon as a one-day cricket match that who won, who lost, and so far the first innings so-and-so won, so-and-so lost, and the ruling was in so-and-so's favor. In judiciary, it happens many times. The judiciary gives the favoring. Ultimately, it takes time to understand what it was, and the Supreme Court will give a very... So even Muslims, for that matter, should not get disheartened by today's ruling, for that matter, that, you know, already security has been beefed up. In Varanasi, there's Section 144 imposed.
Security, you're right about that. Security has been beefed up, 144 imposed. In the morning, we've seen how the city of Varanasi had turned literally into a fortress. But end of the day, there are contentious and difficult issues, and we cannot always walk on eggshells. Sometimes it's important to address these issues and look at history, perhaps try to understand at least what our history says. But Jyoti Adityanath ji has also joined us. He's very well renowned here from Varanasi. So what do you make of this entire argument? Of course, there is, the Muslim side, many who say that today you are asking for the right to pray, tomorrow you will ask for the entire complex, and then this fire will never stop. What would you say today to those who are, of course, espousing an argument in that direction, sir?
Actually, the thing is that this is before 1669. It was a Monday. It was not, actually, everyone knows, and it was not a mosque of Muslims. They all knows. And it is declared in the Aurangzeb Hukamnama. Actually, on the another way, when you say about these things, today, actually, we have studied lots, but there some fundamental rights connected with the Hindu mythology. And when we talk about the Hindu mythology, we can say that this temple, Kashi Vishwanath Mahadev, another temple, Mathura, Krishna Janma, and third one is Ram Janmabhoomi. These are the important fundamental, we have a fundamental rights, and we are connected with this place. You can understand this thing, Lord Shiva himself established this temple. Second thing, Ram was born on same place. We cannot be able to change what today argument with some another learned persons, they have told the same thing. So this is connected with the situation. We have not talked about the 40,000 mosques which was destroyed, which was made by the destroying temples. We are not bothered for these things, but we are bothered for these three places importantly, because these are connected with our mythology, these are connected with the ethics, These are connected with this place, all which is connected with our faith. So, our fundamental right to pray the God on this base, we are talking about that, and this case is on this ground only. Basically, Sringar Gauri Puja, it was offered daily. Then they have stopped and they have made program of the periodical 7 days, once in 7 days.
And that's all their plea as of now, at least, is limited to. KV Dhananjay, the Hindu side also now wants an entire survey to be conducted. They want an ASI survey. They're saying they also want carbon dating of the shivling. What do you have to say about that? Because many today are arguing, what's wrong really? Why should we shy away from probing our history? End of the day, when it comes to historic wrongs, the Hindu side says that we are not after each and every mosque, thousands of mosques, in our country. We're just talking about 3 places which are core to the Hindu belief.
Well, what happens is this: the Places of Worship Special Provisions Act of 1991 apparently is not palatable to many people, because it actually leaves a lot of people feeling that they've been wronged and so on and so forth. But fact of the matter is, it is a law. It binds the civil court, because any relief respecting a temple or a mosque could only be obtained in a civil court. A civil court is bound by that, and therefore, what the previous petitioners have not been able to secure in the Varanasi civil courts so far is a fact, and we've got to accept that. Now, what this case perhaps could do is to, in fact, open up the possibility that what the structure inside the mosque is a shivling, and shivling is not integral, or for that matter, it's not even required for the Muslims to carry on the use of that building as a mosque, and therefore that structure will have to be returned to another place.
So you're saying, I'm sorry I'm interrupting you. You had said this earlier also, that the shivling can be, of course, moved to another place. But the Hindu side also argues and says that the 1991 Act is not going to be applicable in the Gyanvapi case. They say, one, it's a monument should be ascertained by the ASI. And they also say that if by carbon dating it is ascertained that the shivling existed before 1947, that would be tantamount to the 1991 Act being non-applicable in this case. Where do you stand on this?
This is an active mosque. I don't think anybody denies that. And by the way, the civil court here is not situated in a faraway state or a faraway region. The civil court is right there in Varanasi. And the civil court certainly would recognize this building as a mosque. Now, it's it's not that, the law says what it says. And I'm here essentially to say what the law, in fact, would permit, or what the law says. It's not that I might like what the law says. Because if I'm here to say what I want, then I don't think I'm here in my capacity as a lawyer. So the civil court would recognize this building as a mosque. There is no doubt about it. Now, after having recognized it as a mosque, there is no room to treat this as a monument, because a monument or a museum can't be an active place of worship. So this is a mosque, and it certainly is not covered under the other 1958 Monuments Act. So having said that, it's possible that these plaintiffs would be able to secure something that the previous plaintiffs have not been able to, because all of these plaintiffs continue to labor under the difficulty imposed by the Places of Worship Act of 1991. And that special, benefit that these plaintiffs would probably be able to secure is the displacement of the shivling, number one. Number two, 711 application is one where the argument would be that a trial is unnecessary, because the relief that the party seeks is a relief that is barred by under some provision of law. Now, apparently the Muslim side, in fact, has argued before this very court that the Places of Worship Act would bar the giving of all reliefs sought by the plaintiffs. It looks like the court has said, wait, maybe there is some relief that they are entitled to, because what the Places of Worship Act does not bar is if this particular place was being used as a syncretic place, where there would be a puja performed by the Hindu side on some days of the year on the 15th of August 1947, and if that practice continues to be unbroken, and if it was broken only due to a government dictate, if the government came out with a regulation prohibiting it, then limitation is arrested. So it's possible that the court has said that there is some relief that we could give them, and therefore a trial is necessary. So in that context,
you are saying Okay, I take your point. Advocate Khushbu Jain, KV Nanda suggests there can be no hope for the Hindu side when it comes to laying claim over the area where the mosque, currently stands is concerned because of the legal hurdle produced by the 1991 Act. Under 711, he feels that if it goes to that direction, it's going to be untenable. Hindu side, of course, doesn't agree. We all know what their side of the argument is. What would you say? End of the day, Hindus say that they have been denied their rights for far too long. The fact that, Hindu motives, Hindu deities, etc., are very, very clearly visible on the walls of the mosque only goes to strengthen their case.
Yeah, I to an extent agree with Mr. Sumit and also with Mr. Mohammed to talk about that. Let there be a proper trial. No, why are you abstaining? Why are you barring that? Let there be a trial only per se, or let court do not investigate. Let investigation go on. All the facts which you're talking about, let that go on merits. Today, what you're talking about is we don't want to even go to the merits of the case, whether 1991 applies, doesn't apply, whether there existed a temple, whether Hindu deities were there or not, whether they were being worshipped in that premises, till when it was being worshipped. Let those answers be tried by the court. Why are you abstaining? What you're doing today is, all you are asking is, no, this is barred by limitation. We don't want any discussions only on that. Why? There are things, their existence is there. Nobody is denying the existence. Now, what comes to who's right, to what extent, let court decide about that. Now, coming back to the direct question of which Sir was talking just before me, was that, see, when you're talking about, court has specifically held very clearly that since Hindu deities were worshipped inside the masjid complex even after 15th August of 1947, which is the cutoff date for provided under the Places of Worship Act of 1991. Therefore, the Act will have no applicability. I will repeat, the Act will have no applicability here in this specific case. Now, coming directly on the question of Order 7, Rule 11 of CPC, I would say that it just specifically talks about whether at the first chance, whether forgetting about the merits, forgetting about the getting into the merits and demerits of the case, plainly you have to decide whether it is applicable, whether that bar under CPC comes or not, and that is very clearly decided that no, it is not. Now comes the real question that whether what would be decided in whose favor and how much, to what extent the court would go or committees would found. So I think let's all of us wait and watch about that part. But yes, there were rights which were infringed of certain parties, and they should be given proper due in the court to put their stance.
Well, absolutely, and Sumit Peer, and that's an argument which many are making. Why shy away from even having a discussion? Why should you use, just one act as a shield and say nothing doing, we don't even want to discuss it, what existed, before or after, whether, all the Hindu motifs and figurines which were found, they have any significance or not, simply because a right, an act provides us or gives us a legal shield, an act which anyway, against which petitions have been filed in the apex court, which are due to be heard.
I think, Meenakshi, there are a couple of things here. First thing is, we know when you look at the place, and in case of Ram Janmabhoomi, you have to take the help of ASI to dig out facts. Here, the facts are visible to the naked eye, so no ASI is needed. Point number one. Point number two, what does Mr. Jain, the advocate, say? He says, pratyaksh, apratyaksh, pratyaksh, visible, invisible deities. So it's not only one Shivlinga or one thing. There are a lot of deities, there are a lot of sculptures which are inside the mosque which need to be revealed. We only know 4 or 5 of them. Maybe there are 25, there are 100, I don't know. They have to be revealed. Point number 3 is that, this is against what is the basic law. When as per the law, even up to 1994, the puja was happening. So this act doesn't come into place. Point number 4, if a government comes tomorrow, say, the Narasimha Rao ji got this act in place. Suppose, example, I don't know, if Modi ji tomorrow decides that I want to repeal this act, bring a new act, then these acts are not, it's not something which is cast in stone and which cannot be challenged. What is sacrosanct is the Constitution of India. As per the Constitution of India, you cannot deny us as our basic right to justice. How can an act enacted be just tell me, go hang your, go and hang your, it's all decided. That goes against my fundamental rights as a citizen, which is guaranteed to me by the Constitution of India. So nobody is above the Constitution. And last point I want to make is this act itself is under the scrutiny of Honorable Supreme Court. Honorable Supreme Court has sent a notice to the government, say kindly come back and give us your suggestions. What is your position on the act? And let me take you to the section 30 of this act, or section 40, I can't remember clearly, wherein it says if 2 Awqaf Maulvis are to get together, they lay a claim on the land. Now, even in 6 months, you don't claim that land, then you cannot go to the Indian legal system and even claim that land. That has to go to some Awqaf court. So it's kind of a Sharia which has been imposed here. So how can a title case, how can a title suit, if a Ram Janambhumi title suit can go and be in court for 125 years, if here a piece of land is encroached which belongs to me, you're telling to me literally to go to a Sharia court and ask for justice. When we have an Indian legal system up, running, vibrant and delivering, how can we have these parallel two legal systems there? So this act as such needs to be relooked into, and this section 40, to best of my knowledge, is a draconian act. It is brewing trouble today, tomorrow, day after. The trouble will come and hit all of us doors. Before that, we have to get set the things right. It was a one-sided act for, suiting the benefits and needs of one particular community, that's the Islamic community or the Muslim community here. But in a secular India, this kind of thing has to be kind of brought in. You have to make it even. I'm not saying favor Hindus, but make it even, make it a level playing field. Indian courts will decide everything, not some council or some, Sharia,
Okay, no, but end of the day, they're talking about a certain act, but let me just take it forward to Major Mohammed Shah. Major Mohammed Shah, would you say it's also time for both sides perhaps to give up rigid views on the same, even for the Muslim side? Because you just heard what, one of the top seers had to say. They say that we are not laying claim over each and every mosque. We're just speaking of three very important key and critical areas which are core to the Hindu belief. And if there were historic wrongs, what's so wrong in looking back perhaps as to what happened in the past?
Right, Meenakshi, I will tell you the vibe of one WhatsApp group today, and there it was said that, whatever the wordings came today of the court, so someone wrote, oh, as expected. Now, it's too early to say anything as expected or not. In fact, we have senior lawyers over here from the Supreme Court also. They would know better that in judiciary, you can never say till the end. In the beginning, it might appear that so-and-so, the first round goes to so-and-so, second round, you never know. So the court is the best judge. They will have all the evidence. They will have video footage. They will have whatever it takes actually to give out a ruling. And whatever ruling it gives ultimately has to be respected. It has to be respected by anyone and everyone. Whether they like it or not, they have to actually honor that. And my appeal to you, to the nation, through your channel and through you, Meenakshi, is please resort to peace. Please do not resort to violence. Please, even if you are in disagreement with the case, it will lead to making things worse. In fact, a middle path, a middle ground has to be brought out. I don't think that there is any problem in this world which cannot be solved if we actually sit down to actually attempt it, because I feel where we are not a failure until we fail to try. So it's very important to try to resolve any issue, and there's no issue which cannot be solved amicably together in one with a consensus, Meenakshi. So I am quite hopeful still. Despite today's verdict, I don't see it as a beating to Muslims. I don't see that they have taken a backseat. No, I feel there's still time. And let us see what happens and hope for the best and prepare for the worst. Because court would know best. The judiciary, we have full faith in the judiciary. Whatever they give out a ruling, it would be based on substantial evidence. It would be well substantiated. And yes, one should honor that completely.
But, KV Dhananjay, if you could come in here, sir, do you not think that, when it comes to such issues, contentious issues, perhaps we need to give the timorousness with which we are approaching these issues? We can't possibly always be walking on eggshells because there is one side which feels that historically a wrong has been done. End of the day, what's so wrong if they are demanding a full survey, for the carbon dating of the shivling? Why should it be completely negated just because there is an act, which of course shields such places, contentious places like the Gyanvapi complex?
Well, the carbon dating, I think, is fine. But why would carbon dating be required unless and until the mosque puts forth a meaningful argument that the structure is not shivling at all? Because I don't think the mosque would be, allowed by the court to make such frivolous arguments. On the face of it, it looks like a shivling, and a shivling has no place in a mosque, not in the manner in which it's being used. So a shivling ought to be displaced from that place. Now, there are these other niceties, which is you take the BJP party. The BJP party was in fact, they worked out during the 1991 debate on the Places of Worship Act. Now, one might ask that the BJP is already in majority in parliament. What is it that is preventing it from repealing the statute? And perhaps the answer might be that the BJP in the last 30 years might have learned something, which is the situation is not as binary as many people make it out to be. There are active Jain scholars who are in fact coming out with pamphlets and who are coming out with credible, information to show that a good number of temples, very prominent temples in South India, were in fact built after demolishing Jain temples. Now, what happens to those places? Maybe the BJP is quite aware of the kind of difficulty or Pandora's box that would be opened up should they repeal it. So I think any issue, about wanting to correct historical wrong should not just be looked at by taking one particular, event or one particular city as a measure, city or a town as a measure. You have to look at what's there across the country. I mean, there are the Buddhist groups which have, in fact, credible evidence to show that a good number of prominent Hindu temples were built after demolishing. Now, what do we do about that? So the question is this. Now, we had we have had very respected Hindu seers say that, look, these three temples, the Kashi, the Mathura, the Varanasi, and then Ayodhya are in fact so different. But the issue is this: there is not really enough consensus that there are not other temples that are worth building or worth preserving.
No, but sir,
you take the Nanjangud temple in Mysore, which is a very
I take your point respectfully, but should the fear of opening Pandora's box and, once again reinvigorating of these revanchist claims really stop us from finding out the truth of our history? Whether it stands legal grounds or not, I guess it wouldn't be right for me to say. We'll have to wait and watch for really what the courts decide. But certainly, at least as far as the limited verdict for the day is concerned, the Hindu side says that it's a win for their Aastha, it's a win for their faith. If they will be allowed to hold prayers on a daily basis, as is their plea, if there will be possibly a survey, a carbon dating of the Shivling, which they are demanding, or will it be disqualified under the 1991 Act? We'll have to wait and watch. Far as the legal wrangle in the case is concerned, we'll keep our viewers updated on each and every update on the same coming out from the courts. As of now, I'd like to thank all of you, the eminent lawyers, the seers, of course, other panelists also who joined us on this extremely interesting and riveting discussion. It's a wrap on this bulletin. News and updates on the other side.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.